Ready? Exercise number 26, progressive. Start. The Rainbow Papers Limited, of which Ajay Kumar, the appellant before us, was the promoter and managing director, sought loans from a public financial institution, Tourism Finance Corporation of India Limited. The respondent before us, to fulfill its various corporate requirements. The proposal of the company was considered by the respondent and approval was granted for a term loan of rupees 30,000 crores. In pursuance to the approval, a loan agreement was executed in New Delhi in order to satisfy its obligations under the agreement. The accused company issued post dated check of rupees 25 lakhs bearing check drawn on Indian Overseas Bank, Kalupur Circle Branch, Railway, Pura, Ahmedabad, towards the payment of one of the installments on the check being presented to the bankers of the respondent, that is HDFC Bank Limited, Nehru Place Branch, New Delhi. The check was returned for the reason account closed on 19/4/2016. A demand cum legal notice was under section 138 of Negotiable Instruments Act 1881 was issued on behalf of the respondent, calling upon the company as accused number 1 and the appellant herein as accused number 2 to settle the debt advanced by way of corporate loan. Stop. Next para. The accused acknowledged their liability to pay the loan amount. The amount was not paid, and thus criminal complaint was filed in the Court of Chief Metropolitan Magistrate, Saket Courts, New Delhi, under section 190 of the Code of Criminal Procedure 1973, read with section 138, section 141 and section 142 of the NI Act. The complaint was signed and verified by Deputy General Manager under bracket law bracket out of the respondent company. An endeavor for mediation was made but was not successful, and thus the next date was scheduled before the magistrate. In the meantime, a development which took place was that in 2017 Mr. Neeraj Paper Agencies Limited, styling itself as operational creditor, filed an application under Section 9 of the Insolvency and Bankruptcy Code 2016, read with Rule 6 of Insolvency and Bankruptcy Rules 2016, with the request to initiate corporate insolvency resolution process against the accused company, treating it as the corporate debtor. The National Company Law Tribunal admitted the aforesaid insolvency application. The respondent herein filed its claim against the debt, which was the subject matter of the NI Act proceedings. Next para. On 5/6/2018, Committee of Creditors was informed that the respondent herein could not be considered as a secured financial creditor as per definitions contained in Section 3 subclause 30 and Section 3 subsection 31 of the IBC. In effect, on legal advice as such, the respondent was opined as an unsecured financial creditor. This resulted in the respondent filing applications in the form of objections before the NCLAT, where the status was sought to be changed from the unsecured to secured financial creditor. Now, turning back to the NIA proceedings, the Metropolitan Magistrate passed an interim order dismissing the application of the appellant for exemption from personal appearance. This in turn was predicted on the observations of NCLAT opening that Section 138 of NI Act is a penal provision which empowers the Court of Contempt jurisdiction to pass order of imprisonment or fine which cannot be held to be proceedings or any judgment or decree of money claim. Thus, it would not come within the purview of Section 14 of the IBC, and thus the proceedings under Section 138 of the NI Act 1881 could continue simultaneously. Stop. Next para. The appellant thus filed an application for discharge of the complaint case in question herein in the present case, which was dismissed by the Metropolitan Magistrate YD order. The criminal revision petition preferred by the appellant bearing criminal revision also met with a similar fate before the High Court and was dismissed with cost of rupees 20,000 to be paid by the appellant to the respondent. It is this order which is now sought to be assailed before us. Learned counsel sought to urge on behalf of the appellant that the trigger of section 138 of the NI Act is the non-payment of legally enforceable debt. Once the debt is itself extinguished either under section 31 or in process from sections 38 to 41 and 54 of IBC. The basis of section 138 of the NI Act disappears. We may note that these provisions fall under chapter 3rd of the IBC. The term debt would mean legally enforceable debt. Under the explanation